Everybody wants to know what's going on. What options are there for healthcare professionals, medical professionals, researchers, nurses, physicians, and all the allied types of different professionals that work in the healthcare field, because obviously they're of critical importance to the United States in this trying time. So we thought we would put together the kind of immigration options, but more than just immigration options, what's topical, what's going on, what's changed, what's being proposed. There's some bills out there. And we did this with the intent to, to help those around them. It's a very complicated area of immigration law, healthcare and physicians, and it's something we felt that we really wanted to do in this regard. I want to start with introducing my esteemed panel, Avi Friedman and Naveen Rahman Bora. We've worked together for almost 20 years, so I know them very well, and they're both experts in the fields of immigration law in general, but also with regard to healthcare and to travel issues and all the myriad of other things that come with immigration law. Just before we start, I want to just start with a disclaimer. I always start with a disclaimer, simply because we're all lawyers. We have to have disclaimers. And if you look on the first slide at the bottom, everything we're going to say is meant for informational purposes. There's a lot of discussions. A lot of the bills, are not law, and or at least yet. Hopefully, they will become. So. Just like in the medical field, you wouldn't diagnose or treat people based on a webinar. It's critical that you reach out to one of us with questions on specific cases before taking any action and doing anything irreversible with regard to anyone's immigration strategy. So I thought I would start with a quote. Like most of us, we're stuck at home, or some of us stuck at home, and I'm doing a lot of English essays with my children, and everything has to start with a quote. So listen to this quote about immigrants, healthcare workers. Consider this: 1/6 of our healthcare workforce is foreign-born. Immigrant nurses and doctors play a vital role in our healthcare system, and their contributions are now more crucial than ever. Where would we be in this pandemic without them? It is unacceptable that thousands of doctors currently working in the US on temporary visas are stuck in the green card backlog, putting their futures in jeopardy and limiting their ability to contribute to the fight against COVID-19. And that's from Dick Durbin in one of the press releases related to one of the bills that he has sponsored. And I think that really encapsulates the role of immigrants and the importance of immigrants, especially in the healthcare field. So with that, I want to go on to the next slide. There we go. And this is just an overview of what we're going to be discussing. We're going to start with a brief overview of the U.S. work visas and green card options. It's not going to be in-depth view of this. It's just really to give you a taste for those that don't know all the idiosyncrasies of physicians and nurses and healthcare professionals and the way that immigration works with them, just to give us a basis, and very focusing on the issues and the issues that relate to them. We're going to discuss some of the bills. The two major bills are the Healthcare Workforce Resilient Act, the HEROES Act, and we're also going to speak about a policy that just came out recently for international medical graduates. We're going to look at COVID-19 and the effects of this on the healthcare industry and certainly on healthcare immigration. And then we're going to look at some of the other 2020 immigration trends and with a specific look at healthcare professionals as well. All our information you can find on our website at www.wolfsdorf.com, either under immigration, US Immigration News, under COVID-19 Resource Center. This webinar is also available on our YouTube channel. And then I also want to mention there's another webinar, and I can, after this, feel free to reach out to me. I'll send you the link, which deals with visa options for physicians and more detailed nuts and bolts for those who are interested in the real nuts and bolts of physician immigration. As I mentioned before, contact your WR attorney. We are here to help. Our contact information is on the last slide. you know, and this is a complicated part of immigration law. So we simply want to make sure that you deal with an attorney, somebody who's qualified to answer the questions before, you know, self-medicating, in keeping up with the analogy. On this webinar, if you want to send a question, feel free to use at the bottom of the screen. It should be next to the raise your hand button. There should be an option to ask a question. Feel free to ask questions throughout the webinar. If they're pertinent to what we're discussing, the exact point, we'll try bring it in as best as we can. Otherwise, we'll do some questions afterwards, and any of the three of us, Avi, me, or myself, Cliff, we're all available to answer questions at any time after the webinar as well. Okay, so let's go into the issues as they are. The first slide or first question: what's the most common work visa and green card options for healthcare professionals? That's obviously the basis, so that we can move on to the more complicated part. So we're going to give a high-level overview of these. And then, how has COVID-19 impacted the work visa and green cards? We're going to look at some of the memos and some of the proposals, as I mentioned. So I want to start with Naveen. Naveen, why don't you start with physicians, some of the common work visa options for physicians, and focus on some of the issues and idiosyncrasies that relate to physicians and their temporary visas.
Thank you, Cliff, and good afternoon, everyone. So for the physicians, we'll first start with the work visas. The first one on the list is the J1. As many of you may know, the J1 is the work visa for graduate medical education. So if you're coming on, to the U.S. for any form of training, for residency or fellowship, you get a J1. And as once you're on the J1, you actually become subject to something called the 2-year home residence requirement, which will prevent you from getting a green card or an H visa or an L visa until you actually go back to your country of last residence for 2 years. And then there's a way to circumvent that by getting a waiver of that 2-year home residence requirement. And that takes me to the next visa, which is actually the H-1B. So a lot of physicians will be able to get a waiver through the state Conrad 30 program or working for the VA. And they are committed to work at these facilities for 3 years, and they have to convert to the H-1B. And there are a lot of, well, actually very limited programs that will allow certain physicians to do their residency training on an H1, but most of the folks do come on J1s. The next three, the O1, the TN, and the E3, the O1 is for people who are of extraordinary ability in their fields. The TN is limited to Canadians and Mexicans, and the E3 is for Australians. These 3 work visas are great for bypassing that 2-year home residence requirement. In the interim, it enables you to come back to the U.S. and work in one of these 3 work visa capacities, but that 2-year home residence requirement will still remain in place, and you need to deal with that before you can convert to the green card. We've listed the B1 just to note that a B1 is a visitor visa. It is not employment authorized in any capacity. So if you're coming here for an observership, you certainly cannot do anything like touch a patient. It's really just to be observing how a certain practice conducts their medical practice, or you're coming here for your US MLE exams or interviews. Within the green card options, these the 4 that are listed are all employment-based. The national interest waiver and the extraordinary ability can both be self-petitioned. So as an individual, you can petition yourself. There is a specific provision for physicians, and if very similar to the Conrad waiver, if they're committing to working in an underserved area for 5 years, they can self-petition. The other 2, the PERM labor certification and the one for outstanding professors and researchers, those are employer sponsored, so your employer would need to file that petition for you.
So Naveen, why don't you just give us a little bit of a taste of just some of the licensing and credential issues that typically come up with physicians, what you need when for what?
Sure. So you could be an amazing, extraordinary, highly talented physician in your home country, but you're not able to actually work in the United States unless you get a license to practice in that state. And so even though you may be a highly credentialed physician, you will need to come to the US and go through the residency or fellowship process before you can get the state license. And then you will need that license for an H-1B. And then the same thing would apply when you're converting from a J-1, having done your residency or fellowship, and now you're transitioning to the H-1 to work on that Conrad obligation. You will need to have your medical license application approved before you can get the H-1B approved by immigration.
Okay, thank you. Let's move to Avi. Avi, talk a little bit about visa options for nurses, the temporary visa options for nurses. What are the kind of basic requirements and issues that come with these applications?
Sure. Hello, everyone, and good afternoon. So I'll start with talking about the TN. The TN is established via the NAFTA, which is the North American Free Trade Agreement. And so that's an agreement between the United States, Canada, and Mexico. So to qualify for this type of specialty visa, which was established by the trade agreement, you have to be a Canadian citizen or a Mexican citizen. And NAFTA established the TN visa category with various professions, and the registered nurse is one of the categories on the TN professional occupation list. So obviously, if you have to have a valid Canadian or Mexican passport to apply, the requirement is you have to have a state or provincial nursing license or hold a licensura degree. One of the key components from the nurse perspective is you have to obtain visa screen. And basically that's a credentials assessment from CGFNS, where they are looking at your education to make sure it's comparable to a US program in the US, verifying your professional healthcare licenses are in order, making sure you have English language proficiency, and verifying that you've passed the CGFNS qualifying exam or the NCLEX RN. To apply for the TN, assuming you qualify, for Canadians who are visa exempt for the most part, they can apply directly with Customs and Border Protection. This is done at a land port or at an airport. And there are, if you're applying in Canada, you can apply via the major airports that have pre-flight inspections. So you process with US immigration on the Canadian side, fly into the US, and you land. In terms of Mexican citizens, they do require visas, so that means you would be applying at a US consular post, so either the US Embassy or consulate. It does have a couple extra steps involved in terms of the DS-160. Limitations from the Mexican perspective is that the visa reciprocity limits Mexican TN visas to 1 year, although technically the TN for both Mexicans and Canadians can be issued for up to 3 years of status. So from a visa and travel perspective, you may get a 1-year visa, but when you show up at the US port of entry, immigration can grant 3 years of status. Key to remember with the TN and most of our visa categories is that these visas are employer specific. So if you are looking to switch employers, it does require either filing an application with the Immigration Service stateside or going back and applying again at the port of entry or at the US Embassy or consulate.
Okay. Naveen, what about green cards for nurses? What kind of options are there for green cards for nurses? And you can go into the other type of healthcare as well in the same answer, and also maybe just also speak a little bit how the visa bulletin and backlogs affect this as well.
Yeah, sure. So for nurses and for physical therapists, there is a a specific provision we refer to as the Schedule A group, and they've been recognized by the Department of Labor years ago to be shortage occupations. So what this means is if you have an employer who is willing to petition for you, the employer can file the green card petition directly with immigration without having to first demonstrate to the Department of Labor that there are no available U.S. workers. And so through the Schedule A process, the green card process is a lot shorter because you can bypass the Department of Labor and shave off about at least 8 to 10 months of the green card process. And again, this is specifically for the nurses, the registered nurses, and the physical therapists. I also wanted to note that for both of these occupations, there is a visa screen requirement, which is for both people coming in on a temporary work visa, such as a TN, or for the green card. And for the visa screen, you need to demonstrate not only proficiency with both spoken and written English, but also that your education is on par with a U.S. degree. And then there's license requirements as well for those occupations. For the other allied healthcare workers, they would need to do the green card process through perm labor certification, where the employer first needs to advertise and test the labor market and show that there are no available U.S. workers. The registered nurses actually fall under the EB3 category. Within the employment-based green cards, there are 5 different categories, and there is a quota for every group, an annual quota. And right now for this, the EB3, which is for people who are skilled workers or professionals, and that includes the registered nurses, that EB3 category is currently backlogged by well over 3 years. So what that means is the employer can file the green card petition, but you wouldn't actually be able to get the green card in hand at a consulate for at least 3 years, or if you're in the United States, you're not able to apply for the adjustment of status from your temporary work visa or status to the green card.
Okay, Naveen, we have a question from the audience. Is there a way to bypass perm for physicians?
That would be through the national interest waiver provision. So if you're working in an underserved area, you could do the physician NIW where you're self-petitioning, and then you just have to show that you have a 5-year contract or commitment to work in that area, and that is the way to bypass the perm. But for all other green card processes, is through the employer. They will need to file a perm at this time.
Okay. I think I just want to summarize the cases of nurses, just because it's a good segue into the next section. So clearly, if you're Mexican or TN, Mexican or Canadian, you have the option of a TN. But if you're not Mexican or Canadian, then there's no TN for you. There's usually not an H-1B for you because most nursing positions don't require bachelor's as a minimum. Some do, but most don't. If someone's on F1 OPT, there's no, it's not a STEM field, so it cannot be extended. Schedule A for the visa bulletin is in the EB3 category is now backlogged, so there's no option to file concurrent I-140s and immigrant petitions with adjustment of status to get work permits. So, for a lot of nurses, especially nurses, they need a lot of help. And some of the bills that have been proposed are, are aimed to answer these kind of questions. So I'm going to go back to Naveen. We're picking on you quite a lot, but Avi, you'll get your turn too. Why don't you talk about the first bill that was proposed, the Healthcare Workforce Resilience Act, and what that does for healthcare workers?
Yeah, so we're actually really excited about this bill because what it does is with that annual quota of green card numbers, there's a lot of unused visa numbers that are never applied. So this bill, which is still very much at the initial stages, but what it proposes is to to take from that unused quota 25,000 immigrant visa numbers for registered nurses and 15,000 immigrant visa numbers for physicians. And this would then enable a situation that Cliff just described. So if you're a registered nurse graduating off of an F1 OPT, if you've got an employer willing to file that Schedule A petition for you, you would have an immigrant visa number readily available and would be able to apply to adjust status at the same time. And this is huge for Indian and Chinese-born nationals who are physicians and have been in line for a green card number for the last, I don't know, 8-10 years now, waiting for their priority dates to become current. So by pulling 15,000 numbers, back in for them, this will not only alleviate that backlog of green card numbers, but it would also trickle down and help with the backlog of others, Indian-born nationals who are also waiting for their green card numbers to be available.
Okay. This bill only refers to nurses and physicians?
Yes.
Okay. What about medical researchers?
No, this is specifically for nurses and physicians. But again, the idea is that because it will clear up, a vast number of visas for other people. So if you're not a nurse or a physician, it should clear it up for others as well.
Okay. Thank you. I guess that's a good segue into the next bill. There's another bill out there called the HEROES Act, which does seem to be more broadly, applied to healthcare workers more broadly than nurses and physicians. Why don't you tell us about this bill?
Sure. So this bill is actually pretty amazing because it's not just for healthcare workers. It does have provisions for, the first provision is actually for anyone who's in the United States. As of January 26th, they're given an additional 60 days to file an extension or a change of status. And then, if you're here as a permanent resident applying for naturalization, there is a provision for conducting the oath ceremony virtually. So this bill is pretty broad in terms of the number of people who would benefit from this bill. There is a provision for work authorization and deferred action for anyone who's providing critical infrastructure work. So that's also fairly broad, not just for healthcare and public health, but also for people in, let's say, law enforcement, energy, financial services. And then within healthcare and public health, that's also a fairly broad provision. It includes everyone like dentists, pharmacists, therapists, home healthcare workers. So it's fairly broadly written. Specifically for provisions for physicians, there is a provision for somebody who's completed their NIW, which is the physician NIW obligation, where they've actually completed their 5 years. They're now able to apply for adjustment of status without having to wait for an immigrant visa number. So as we had previously discussed with, for example, the Indian-born physicians who are waiting several years for an immigrant visa number, if you have an approved NIW I-140, you've completed your 5-year obligation, you're able to file this adjustment of status application without having to wait for a visa number.
Okay.
There's also a provision for expediting without having to pay that exorbitant premium processing fee. There is a provision for prioritizing visa processing for physicians and also for increasing mobility of the healthcare workers. So if you are, there's a provision that if you're working and you want to do telemedicine, you wouldn't have to file an amended petition to work at a different facility or to provide telehealth services. And that also extends to J1s as well. For O1s, if right now, if you're going to change employers, you do need to wait for the O1 petition to be approved before you can start working at the next facility. There is a provision similar to H1s that as soon as the petition is filed, you can start working at that new facility. And lastly, with the CONRAD waiver provision, the CONRAD is the state 30 provision where it's for people who are subject to the 2-year home residence requirement and they're going to be working in underserved areas. That CONRAD provision typically sunsets every couple of years, and this provision would make it a permanent. And there's also what we're calling an elevator provision, where right now there's a quota of 30 per state, but that will increase to 35, and there'll be like 5 slot increases depending on how many CONRADs are applied and granted in a fiscal year.
So we have a question from the audience. They want to know, well, the first bill clearly deals with the country cap. Does the HEROES bill deal with quotas and bringing forward priority dates?
So there is, well, it does for the NIW physicians, and but not, aside from just the deferred action and the employment authorization, I don't see a provision for bringing forward priority dates for.
So what you're really saying, we need both these bills passed.
Yes.
Okay, sounds.
Yes.
Okay, so sounds good. Let's move on. We do have a lot of questions. Some of them are I will still intersperse, but we will leave some time at the end to go through some other questions as well. Naveen, before we go to Avi, just one more policy member that came out this week relates to those on H-1B visas pursuant to fulfilling their CONRAD waiver J1 waiver requirements. Why don't you tell us what came out and the update on that?
Yes, so at first we were really excited about it, but it's actually very, very narrowly tailored. What it's basically saying is that if you're currently working to fulfill your CONRAD waiver obligation on an H1, and you're not able to work due to quarantine or illness, that you're not going to be penalized for that. They are, however, all the requirements that the employer has are still in place. So the employer, if they want to reduce hours or change pay or things like that, they would still need to file an amended petition. The other provision that they have provided is that so far, immigration hasn't really spoken about telehealth, and this memo does say that you are able to provide telehealth now, but only for patients in the same state that the contracting facility is located. So you can only provide telehealth to patients in your state. This is, of course, concerning for people who work, on the border of states, and their medical facilities provide services to neighboring state patients. So that right now is not allowed. The only exception is if you're working at the VA.
Okay, and I imagine this is a licensure issue.
Yes, although there are some states who have, they have provided some leeway and emergency waivers right now to enable people to work across state lines as long as they're licensed. But the immigration and the federal government hasn't quite caught up with that yet.
What I thought was quite interesting in the memo, it says that with regard to telehealth, the government said that it was silent. The regulations were silent with regard to whether telehealth was a permissible way to fulfill the J1 requirement. So they said that they were putting in this interpretation because essentially, because it was silent, it is somewhat of a reasonable interpretation of the regulations. Now, does that mean once the COVID national emergency is over, that would still be considered a valid interpretation, or are we saying, are we being conservative and saying, well, it really would only apply, you know, this lenient opinion, it only applies based on the COVID national emergency?
Yeah, this is only through the end of the public health emergency. So once the public health emergency is lifted, I don't believe you would still have that same benefit.
Okay. 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 So we've picked on Naveen a lot. Let's speak with Avi. Avi, why don't you tell us a little bit, about, especially as it relates to doctors and healthcare workers, what are the effects of, the northern-southern border being closed and some of the other travel issues that typically come up with healthcare workers?
Well, especially for those that are not able to change status within the United States, the impact of COVID from both the visa and CBP processing has been impacted. And so we'll start, in terms of the northern and southern borders, the United States, in conjunction with Mexico and Canada, they've all agreed to close the land borders for non-essential travel. Generally, healthcare workers, those traveling for medical purposes or for response to public health purposes are exempt and are considered essential travel. But both Canada and Mexico have placed their own restrictions in terms of being able to enter those countries. So if you're not a Mexican or Canadian citizen, you're going to have issues potentially traveling to those countries. And so in the past, especially for those doctors that do not have a Conrad waiver, and so they're J1 subject, and they're looking to apply for an H-1B visa, in the past you would schedule an appointment at a U.S. embassy or consulate and apply for your visa and re-enter. And this leads to the next point in terms of the Department of State has suspended visa services at all U.S. consulate posts throughout the world, with the provision that they are providing limited emergency visa appointments. So it's not so easy to schedule a visa appointment anymore, and it's not so easy to be able to travel outside the United States to catch a flight, to another country and as well schedule your visa appointment. There are exceptions, as I mentioned, for emergency visa appointments. Department of State did mention last month that they put out a short memo in terms of updates on visas for medical professionals, that those who are working to treat or mitigate the effects of COVID-19 are good applicants for emergency visa appointment requests. And so if you go to most US embassy or consulate websites, they do have links where you can submit a request online to request an emergency visa appointment. Those do get reviewed, and if you qualify, they will make an exception and schedule you for a visa interview. Keep in mind, there's still, even if you do get the visa interview, you're still going to be subject potentially to administrative processing, security clearances, depending on your field, and there could be some time until you receive your passport back with the visa. For those that may not be able to travel, schedule appointments, or catch flights, there still is the option to do what's called a 212D4 waiver, a very technical term. And basically what that means is that Customs and Border Protection, these are the officers at the ports of entry, do have discretion to waive both the requirements for a valid visa or a valid passport. And so at their discretion, and it does require high-level approval at that port of entry. And these aren't, you can't just apply, show up, and expect them to do it. It takes a lot of work behind the scenes to try and see if they'll be willing to accept it. But they do have discretion, and especially for physicians who are working in the field and treating and dealing with COVID, they may be considerate in applying for that. And so how this would work in effect is that, you have to depart the United States. So you have to make a meaningful departure from the US. So generally in Canada, that means you'd have to get into Canada, turn around, the term of art that they use is called flagpoling. It's basically just getting in so you can get back. And then processing with Customs and Border Protection, showing your approval notice for the H-1B, and CBP can grant you an I-94 and admit you into your H-1B or O-1 status without a visa. So this is a discretionary process that they can do. It's not something that I would recommend you take on without the assistance of counsel. There's a lot of technicalities to smooth out. TN applications are still being processed at the border, both land borders and at pre-flight inspection. So the key with the northern and southern border closures is it's the land borders. In theory, you can, if you can catch a flight, you still can fly from Canada or Mexico to the United States without the general restriction. So those are some of the main issues, and in terms of both the visa side as well as the admission side.
Okay, so Avi, just to put you on the spot a little bit, if
Sure.
you've got a J1 physician that's subject to the 2-year rule, and they haven't got a waiver and they haven't completed the rule, and they've got an O1 approval to go to the consulate and get the visa inserted in their passport, but they can't get out of the United States, or they can't get an emergency appointment. Would you send them to try to say the Canada border to try and get a visa waived and be entered with the waiver?
I would definitely give it a shot, and this takes some work in contacting the port director at a specific port. Not every port is as amenable or willing to process these types of waivers, so we really do have to look for them. Might be couple of factors. If you're going to be doing this in Canada, then the physician would need to have a valid Canadian visa to be able to enter into Canada. And so if you don't, or maybe possibly be visa exempt. So if you don't have the Canadian visa or not visa exempt, that may be a little bit of a setback in terms of timing. But if you are visa exempt or you've got the Canadian visa, then it's definitely a good option to explore. And the nice thing about it is if they're able to do this, they can do it rather quickly. And it's a one-time admission into the United States. It's not a travel document. It's basically waiving you in for the specific purposes, understanding the emergency situation here, and it's a grant of status. The second you depart the United States again, to be able to get back into the US, you definitely will need to have a visa. So it's a one-time exception that they can make. Okay.
So now you have a visa, or you manage to get one of those expedited appointments. How do travel bans work together with that in order so that the healthcare worker can get back into the United States?
So that's a really interesting one. President Trump has enacted various executive orders, and he's provided various travel bans, and it started, if we go back in time, it all started first with China, and then moved to other countries, and basically saying if you were within one of those countries, China, Iran, most of the EU countries, and then it spread to UK, Ireland as well, and then the northern and southern border closure, then there were restrictions on being able to get back to the United States. There are exceptions, specifically for spouses or children of U.S. citizens. There are national interest sort of concerns here where they can waive the requirements, but it really does have an impact because a lot of times the airlines just see this as an outright travel ban. So if you've been in that country in the last 2 weeks, the airline may not be aware of the few exceptions and may not allow you to board, and trying to coordinate with the airline and with Customs and Border Protection is quite a bit to do. And then the most recent travel ban, which came out towards mid to late last month, again by executive order of President Trump, was an immigrant travel ban. It's basically saying they're not going to schedule and issue immigrant visas for folks that have paths to a green card. And so those have been postponed And what's going to be on the horizon, which may come out possibly in the next couple of weeks, is restrictions on non-immigrant visas. So that's sort of to be continued if and when there is a new executive order dealing with non-immigrants. But for now, if you're outside the United States and you're applying for an immigrant visa, there are restrictions, and there are several minor exceptions as well to the immigrant visa travel ban.
Right. So the different bans work together. There seems to be some confusion that if you don't meet the most recent immigrant travel ban, then it allows all non-immigrant visas, even from countries, say from Europe and China, to come to the United States. Is that correct?
Well, I still think the other prior travel bans are still in effect. So if you've been in China in the last 2 weeks, so you're going to be barred from traveling to the US, but it doesn't stop you from going, the rest of the world is not subject to the travel ban. So if you can make your way, let's say, to Mexico, or you can make your way to Australia, and you spend 2 weeks there, then in theory you should be able, if you have a valid visa, you should be able to travel to the US at that point.
Okay. Let's move on. We're coming to the end of the presentation. So, oops, wrong way. Avi, just speak a little bit about some of the trends impacting immigration and how they affect healthcare workers as well, some of the more general trends.
So what we're seeing, from the current administration across the board, even prior to COVID, is a restriction on the U.S. immigration process and trying to make it more difficult, more burdensome. And one of the tools that the Trump administration came out with was providing new rules in terms of public charge and limitations in terms of what benefits are considered to be considered in terms of public charge and admissibility, taking various types of government benefits. The other focus under President Trump has been his catchphrase BAJA, which stands for Buy American, Hire American. Every visa category that both USCIS and Department of State are considering in their adjudication processes, they're looking at how does this benefit the United States? How is this particular job or employer providing jobs to Americans? Clearly, immigration is a hot topic for the upcoming presidential election. You can see the restrictions that the administration has put into play, and Congress is trying to alleviate some of that, and hopefully, these will pass, or something will pass that will provide and alleviate, the healthcare side of things. But for all other fields, we are seeing quite a bit of restrictionism. And this latest executive order is one example, and many are predicting the next executive order dealing with non-immigrants is going to put quite a damper on some of the non-immigrant visa categories and make it more difficult to qualify and to get visas. The other thing we're seeing is extreme vetting by Department of State. One example is, if you recall, when you're applying for a non-immigrant visa on the DS-160, you have to list your social media accounts. Department of State is going through that, they're reviewing it, and if there's any inaccuracies or you leave things out and they find it, there can be fraud or misrepresentation findings, which ends up with a permanent bar to immigrating to the United States. So DOS, Department of State, is looking at that. Customs and Border Protection during the admission process, also doing extreme vetting, looking at people's electronic devices, social media accounts, seeing if there's anything that could potentially lead to a ground of inadmissibility. Again, from the visa perspective, many visa applicants are being subject to administrative processing on the various security clearance side of things. So it could be a name check, it could be technology check. These can be very lengthy delays from weeks to months, and on some name hits, these can cause year-long or longer delays while the various government agencies conduct security checks and then report back to Department of State. So the trends right now, unfortunately, even before COVID came into play, is restrictionism from the current administration, focusing on limiting various visa categories, and of course, extreme vetting and admin processing increasing.
Okay, so let's before we go to questions, and there've been quite a lot of questions, so that's good. So I just want to summarize with some key takeaways, and then we'll go to the questions. Unfortunately, I don't think we'll have time to answer all of them, but we'll do the best we can, and feel free to follow up with any of us after the webinar if we don't get to your questions. So just in terms of key takeaways, advocacy is obviously very important, especially now. We've got some really promising bills, you know, two bills that would change a lot of lives, especially for healthcare professionals, some more tailored than others. But I think advocacy is critical at this point. You know, speak with your employer, medical institution, your university, professional associations. They all have advocacy, and if you don't know who to do any advocacy through, then feel free to reach out to us so we can help you as well. But you know, the bills are certainly, you know, I think this is a unique opportunity for healthcare workers. I think whether you're political or not, whether you're on the left or the right, I think one thing we can all agree on is the critical nature of healthcare workers. So this might be a unique opportunity. So it's a unique opportunity to start processes, to advocate. Telemedicine is going to be something that we're going to see in the future. It's, you know, I see telemedicine as the Zoom of the medical immigration world. You know, it's going to be something that's, I think, going to be here to stay, and it's going to change hopefully for the good in the next few months, maybe a few years. And then finally, you know, again, don't self-medicate, don't self-diagnose, be careful and reach out to one of the attorneys. So with that, I'm going to go to the final slide. It's going to have our contact details. Feel free to reach out to any of us, and let's start with questions. So I'm not going to do any censorship. I'm going to read the questions as they are, and then you know, we'll answer them as best as we can. So are dentists also considered under the physicians category? Naveen, why don't you answer that?
Sure. So they are considered within the HEROES Act. So for all the provisions that apply to the, you know, for the essential workers, essential critical infrastructure workers, the dentists are definitely included there. I don't believe they are included in the other bill for increasing the visa numbers. The one that's limited to physicians and and nurses, but I have heard that I think that the dentist you know, groups are making that argument that they should be covered as well. But from the reading of this bill, it doesn't appear to be.
Okay. Let's see. Some very long questions. Why don't you deal with this question? How are the Resilience Act and the HEROES Act different, Naveen?
So the Resilience Act is very limited to just increasing the number of green cards for physicians and nurses, and you know, this 15,000 number, it is supposed to be large enough where it will alleviate the backlog for some, you know, through current, so everyone would become current. All the Indian-born physicians who've been waiting, they would all become current. So the 15,000 should cover everyone. And then the HEROES Act is much more broad. This 15,000 number is a one-time number. It's not an annual number. So once it's used up, it's used up.
Okay. So this is a question, is there a separate bill for physical therapists? So I'll take that. It doesn't seem like there's a separate bill. There are two bills, one for physician and nurses, and then one for all the allied workers, including physicians and nurses, but that would all seem to also include physical therapists. Let's see. this is a question, if you still need a J1 waiver for the Healthcare Workforce Resilient Act. Naveen, why don't you take that?
Yes, you do. So neither of these bills take care, I mean, it doesn't do away with the Section 212E to your home residence requirement. You would still need to get that waiver provision addressed.
Okay. This is a question. Is the Schedule A available to nurses who are in managerial positions, for instance, a VP of nursing or manager of nursing, specifically if a prevailing wage determination comes back with the medical or healthcare manager code, so it doesn't come back with a nurse code? Naveen, how do you feel about that?
You know, we have done Schedule A for somebody who was more of an administrative role, but we made sure that the prevailing wage still had the registered nurse classification, SOC code.
Right, so you feel they are doable?
They are doable, but you would need to address and say that this person is also working, you know, doing some basic RN work, and in addition to that, having the administrative duties as well. So
Right.
I think it's doable, but you should get the
right. So it certainly wouldn't be your straightforward nurse case, but you know, for instance, nurse practitioners are their own separate code, occupational code. I don't we've never had any problems with nurse practitioners. The question is, you know, whether it is a nursing position, and I think it is. Obviously, the nurse manager or position would have to have the nursing credentials as well. That's for sure. Okay. What is the status of J1 waiver applications for the EB1 path? So if you need a J1 waiver, what are the options for you to get a J1 waiver? Avi, you want to deal with this?
Sure. So, I mean, the waiver options are still the same. Most will go on to a Conrad waiver, which requires 3 years in H-1B status in a medically underserved area. There's also interested government agency waivers, such as the VA also requires 3 years in an underserved area in H-1B status. 2 other waivers to look at are the persecution waiver and the extreme hardship waiver, which requires that you have a U.S. citizen or permanent resident, anchor relative, meaning spouse or child. And as we talked about earlier, the Conrad waivers, those do allow you to change status from J to H. Some of the other waivers do, normally the requirement is you can't change status. Even with the waiver, so that you have to apply, you may have this H approval, but to activate it, you actually have to travel abroad and apply for the visa. And that's why we talked about some of those options for getting around the visa application.
Okay. Naveen, has there been any update from HHS on waivers?
They have, yeah, they made an announcement to widen the group of HIPSA locations that would qualify. So in the past, HHS was very limited on which facilities would classify for to qualify, and they have made it easier for those facilities to qualify now.
Yeah, and in addition, I heard that for the research, the HHS research waivers, typically they've been taking very long, up to 2 years plus, to hear back, and they've been very understaffed, and that board members resigned. It sounds this is what we're hearing is the reason, but we've heard that they've also added some board members, so to speak, and reviewers. So hopefully the HHS waivers are also going to decrease in time, based on the pandemic. Everybody realizes that we have to do something for these doctors working, that are doing key research and working in underserved areas. Okay. Let's see. Will medical researcher, biological scientists under EB1 I-140 applications fall under the category of any of the acts? So would that help? I assume that means in terms of backlogs. Naveen.
So that classification would certainly be covered as somebody who's under the essential critical infrastructure worker, which is very broad and who falls under the healthcare public health worker occupations. So that's more for the work authorizations, but that doesn't really apply to the increased green card numbers, though. There is one provision in the HEROES Act about carrying over or rolling over unused visa numbers from prior years. So maybe that would help others as well.
Okay. What about Navina? What about genetic counselors? How do they fit in? If you're a genetic if you're looking for a green card, and there's a backlog, where would you fit in this framework?
Again, it's the same thing where you could potentially benefit from the HEROES Act, and I just want to reiterate that neither of these bills have passed, so nothing is effective right now.
So don't forget your advocacy.
Act, yes, so definitely push for the bills to be passed. So the genetic counselor could potentially benefit under that essential critical infrastructure worker provision. And then, of course, if the other bill passes about increasing visa numbers for physicians, that would trickle down to everyone else as well.
Okay. We have a question, and I assume these are green card categories. Which green card categories can you apply without a sponsor? Naveen.
So under the employment-based scheme, it's the EB1 as a person of extraordinary ability, or if you're a physician, the physician NIW, where you're working in an underserved area for 5 years. There is also a national interest waiver category for everyone else if your work is considered to be in the national interest. So certainly if you are doing research that would help with the COVID pandemic, then you can make a great argument that your work would be in the national interest.
Okay. Avi, this is a question. There's an option for retired nurses from India. Is there an option for retired nurses from India, or is it just for fresh graduates from US colleges?
Did you say retired nurses?
Yeah, for retired nurses, I assume, is it just for new nurses, or experienced nurses? And number one, and number two, how does the fact the person's from India affect this?
Well, from the non-immigrant side, if you qualify under the H-1B category, it doesn't matter if how long you've been working in the field. The key is based on your degree. So if you've got an advanced degree, the better the chances. So if you've got a master's degree, and the position is a more advanced type of position, so it could be a nurse manager or advanced practice registered nurse, then you may qualify. But as we mentioned, there's licensure, there's all these other issues in terms of getting the degree credentialed, and so you have to go through that process, whether you're a newer nurse or you're a veteran nurse. Okay,
so we've come to the end of the time. Naveen and Avi, maybe you just want to take 10 seconds, just one final, a couple of lines of words of wisdom just to leave us. Naveen, why don't you start?
So, as Cliff had mentioned, we have a unique opportunity to have, either of these great bills passed, which would really alleviate the healthcare worker issue in the country right now. So anything that could be done for advocacy, we just want to really encourage everyone to, even as an individual, to contact your local congressional representatives and, provide your support for these measures.
Thank you. And Avi?
I would say, we are seeing quite a bit of limitations from the administration and putting up roadblocks for those in the health industry to, to be able to travel either in or out, activate visas. And so while it is a difficult road to travel, I do encourage those that are having issues or seek, assistance to reach out to counsel, because there are ways to request these emergency appointments, visa appointments, to assist with travel back to the US, or do some of these creative type of processing at the land ports with CBP. So there's still options out there. They're difficult to do, but there's still some viable and creative options for you.
Okay. So that wraps up our webinar on the healthcare, the situation of immigration in the healthcare. There were a lot of other questions that we didn't get to, unfortunately. Some of them were very specific and probably didn't lend themselves to this type of forum. So again, feel free to reach out to me or any of the other panelists by email or setting up an appointment, and we'll be happy to help with you. Thank you, everybody, and stay safe.